Yeah. But it never.
Yeah. So, as after, right, who's back to some.
Did you have?
Her name.
But.
She says, they never got that. Yes. Oh my.
Yeah, but they're not ready. They got.
Right. And I didn't have them. So-
Good morning.
How are you?
Good, how you doing?
Do I see you this week?
You have not seen me this year. Happy New Year.
Yeah.
How have you doing?
Good. You have a good holiday?
Good.
Good.
You know what, you know,
Yeah,
I'm trying to make sure I have something from the ashes.
You're absolutely right. What's up?
So this
Right. Yeah, that's exactly how.
Generally.
Right, that was me.
Yes, understood.
Worked out.
I mean, all I know is what Judy does.
Yeah.
Like case management, case and then like keys.
Yes.
Like one place with this one.
Painful.
I mean, it's on this case. You decide.
September 20th. Today's the 8th. Yeah. Yeah.
Well, I mean, if you.
No,
we
that's me
need
too,
to-
like I can
to
tell,
follow-
I know there's.
Yeah, I just heard it's just a lot about
I don't know
that.
where it is or where it is, and I can probably find it pretty quick.
Yeah.
But that's
Right.
Exactly.
I was with you. So I tried to call, but I figured I was like, what's the rate? So we need.
That's all right.
All great.
It's a vibe about it. Yeah.
Great.
Yeah, I follow.
Okay, well, I'm gonna let you know.
Completed a,
Yes.
Like I said, like, of course. So I need like a.
Yes.
But it has to be.
One of
for
them
our-
has been-
So-
They're excellent.
No, one of them has been prepared. It's going to the grand jury, next week.
Next. week.
The other one is still very preliminary. There's nothing, I couldn't even put anything
I almost wanna walk away.
if because the offenses are accusable. So, I'm going to ask my investigators, can I put the stuff together that I need? And if you file a waiver, I'll go ahead and accuse the case. The other one, as I said, is prepared and on the way to the grand jury.
New card. Yeah, I was.
So, once all of that is done, I'm assuming you're interested in a global resolution.
Well,
Or not.
I wanna see, because I don't use this 22. I'm realizing that's probably. So I don't even have
Everything
anything
that
to
belongs to
say.
us.
I do want to see the discovery.
Exactly, so.
For-
Exactly, so I'll undertake to get my investigator to go ahead and put all the stuff that I need. And if you, file the waiver, then I will be able to accuse the case and serve the discovery.
So I will, well, he's all, he's already had it.
But I mean, I think so we'll actually be doing trial.
Is that mine? So, but I know he's only been for trial. It's free.
Now, I will say this, though, you also could.
I think this one, it's definitely like two traffic.
Yeah, I would not, I mean, and as I say, you are not on one of one. So,
Cause I think you said it, but it was like a draft.
I think he's not being held.
Okay.
Yeah.
And I told her, yeah, like, hey,
Usually we said,
Mhm.
is then if that
Well, I'm gonna.
other one is in like a
So,
short.
we just
date,
did him not.
Then he can.
That's why I recognize.
Yeah, so it's not
Okay,
final.
great. I will,
Once
I'll
we
look
get
at, I'll
this,
take a look at
go
what
through
you
all
said
the
in here,
different
because we going to accuse it.
can't be-
And,
we're not ready for this.
Right.
and I'll start working on that, once you forget the evidence.
Okay, I appreciate it.
The only thing that might be.
Yeah, I have a client who I told the seventh.
With that, it's a drug case.
Oops.
Yeah.
Yeah,
I'll reach
that's a
it out.
problem.
Who actually told you?
The GV. It's
Hasn't been
taking-
helpful that I've.
Took it over last time.
That's what I figured was.
Pharmacy,
Barbara Delaney. We'll see, we read. He got it.
Let me see.
Okay, wow.
Oh, it's 15. Because we need to put up-
Yeah, you have to step up.
Yeah.
That's a
because
year.
I don't,
2 years.
I don't recommend.
Yeah.
kind of custodial agents.
It's 2 years. They just see me, I'm walking around. It's 2 years and then he decides he wants to do it.
You go down to Really?
That's what I just found. Oh, wow, okay, it's interesting.
Let me get this message to, well, first we're hoping that
Back,
that. the
Oh, she is?
back.
Fingers crossed. Yeah.
Well, I gotta talk with her.
Yeah. It's not too old.
It's not too old. And he's, well, he's in jail, but he's being held on the other one, nothing, and then he's.
He's being held on both the newest 2023. He filed on that. The one that's on today's calendar.
But I know, yeah, she was in.
Okay.
And then
So
the.
that's the one. We're gonna- Once we can get the evidence.
Okay.
Right, I wanna say it was.
So let me get my investigation. Yeah, that's fine. Because that's going to be
Right, you're right, because I've
the
seen
one, the thing that's gonna hold it up. So are you looking for any kind of bond for him?
He's in the final two on 23.
Mhm.
So, I don't know. I mean, I've never had Judge Meehan said that at the on a pre-indictment case. I think it's that way to go. Judgment.
Some judges will do that. But a week ago, they called
Yeah.
them.
Yeah. So I'm not sure there's anything real on it today.
No,
Um,
so we can just defer the
Yeah.
further notice for perhaps another panel.
Well, I think, yeah,
Maybe-
it's probably
maybe-
next month.
Yeah. Maybe.
Yeah.
He doesn't have free time.
Jeez.
It's about that time, you know, it's.
Yeah, and you know,
9:45.
and you know what? I think it
I
can
would
be.
say, I would say 60 days out,
No.
just because.
Oh,
of-
you know,
Uh,
new.
Hopefully they have that.
Yeah. Okay, so what would be the announcement regarding the power plant?
I'm just gonna say we can both agree to reset this, given that he's not being held on this and we're still working separate two cases that shape up. So, yeah, I think that's all for that.
Let me go with.
That way it's on.
Yeah, I'm meeting in front of.
Well, I'll work on accusing the case as expeditiously as possible.
And then I think number position 12 with Simpson.
Yeah, okay.
She just
I
had
just told her that.
Oh,
She
that's-
did.
He didn't know.
Oh, this is a deed case.
The,
Yeah.
We just talked
I'm
about
not sure
it.
if it's a, it might be a cat case.
I was told that
Oh, I got that too early.
Is it?
it was Calvin White case.
Yeah, it should be a cat case.
See who's even coming.
Everybody make sure y'all phones on silent.
And that would be-
It's not-
Yeah, yeah.
It's not, no.
It's not ain't gonna do here.
That decision was made after.
Hey, you're number two.
Oh, okay. Made after yours.
Yeah.
You think it was a-
I know.
That is going to be
Yeah, everybody got it.
Adrian Clark. She's
I
taken
do.
over from Adrian Marsh, but I'm not sure if she is.
It's not
now.
here.
Yeah,
I'm just saying.
Thank you.
Okay.
I know it's not here.
But you were one is out. Yeah.
No, ma'am.
Oh,
She's still okay.
okay, so there's a, it's on here.
It's on final plea.
Yeah,
What's the,
My stomach was growling.
it says, this one, it says it's, purpose March, but I know she has moved.
yes, first, it's, Robert Simpson. No, person.
Oh. I was just going to eat. No,
No,
we were just talking about this case, but this is.
Yeah, let's be nice.
no, you can say that. I'm going to- No, no, I'll have one.
Continued term of the
I
prosecutor.
think you wanna have one too. Okay, never mind.
Yeah.
Never mind.
Yes. Is that your favorite?
It is. The other one's a little sassy. This one's a little sassy. It's like me, Kathy, Beth. It's a little sassy.
John,
Okay, sure. Oh, you have all the murder. Okay.
Absolutely, forget about it. Miss Bennett, that wreck was like.
Yeah, it was a club.
Eh.
Okay, so it looks like we're headed to Chicago.
I was like,
Yeah. That's all I was thinking.
What's the fine thing?
Oh, no, this is the-
I came in front of the thing.
My recommendation, would probably go down, but we'll have to.
okay, so we can certainly, you know, discuss if there are on that trial docket.
Okay.
You hear? But we can continue to talk. I just wanted to let you know that at this point, that's the.
No, that's fine. I mean, I would look at it. And as I
Yes.
said,
And I'm
my
always-
other candidate is,
And he's gonna take.
can be amended, but they're good. That's a starting.
Gotcha. Kenneth Blackwell.
I appreciate
That's
that.
what I don't- that's me.
Oh, it is.
Yeah, it's.
It should be.
That one?
23 SC 186.
What position?
38.
Go to Orlando.
You'd have to ask, right?
Stay in the morning.
19.
Okay.
All right, please find this.
It's finally come out. I was gonna ask about that because I saw all the notes, but it doesn't seem as if it was ever taken to Georgia Regional.
I don't know that
Or did they,
ever.
was he participating in the prison competency program, the jail?
The jail, I think it
Okay,
was.
okay,
Yes.
so he's competent?
Marginal. So he's not competent for trial, but he's competent for.
I know.
Okay. Okay.
Well, the next year. I'm singing, that's my favorite.
Is there a report?
Somewhere.
Did you have an offer?
I thought I did, but you know, all of these books that I have,
I just say, I was looking at me off.
I confused them.
Okay.
Maybe I saw. I think everything.
I don't saw anything.
It's okay.
Well, not that's a stress.
So he basically says, he's not substantially probable Payment of properties and trial we receive in the future. However, he is confident.
Yeah, so, yeah,
Proceed with
because
that.
we have to split it.
So I'd like to stand here.
Today.
Yes, he's been in custody for.
Have you put on before, because I don't see anything. I don't see anything in my system regarding an offer. And, and I would need to be, I need to speak to my victim. I'm sure we can do that today. Because I don't see any
Well, the
notes
victim
regarding
is the
that.
police officer.
Because I still need to speak to. Yes.
You know, let's just.
We
just work it. Probably. Mr. Bridges.
Okay.
When I was trying to work this out, 'cause he's been in custody
Let me, hold on, see, Billy.
forever and years. Let me see.
I'm gonna say you. All right,
That's the report right there.
Okay.
The final one.
that's the final report? Okay, then.
Well, that he's competent to proceed with the plea, but not competent to trial.
Hey,
how are you?
all right.
How are you?
We
Good.
should.
Never will be.
Yeah, well. Okay,
This is just one that we inherited from non-complex because of the competency issue.
okay.
You over my knee. In town, you're hiding first.
Just that you.
Oh, total?
I had no idea. I got her.
65 seconds.
I think we're gonna watch it.
Before that, we was split.
What time is it?
Maybe 2 years in court.
Do you think you'll be able to, do you think you'll be able to
I'm coming in.
comply with any conditions of probation?
You'll have to have mental health, mental health probation, and basically, if you can get there, as a golf club. I mean, he's not competent for trial, and
Because
they don't really have
to.
room for him.
Because with these kinds of cases, I would normally ask for, a certain standard such as for instance, in his situation, not be setting him up to be violated.
Yeah, I mean, he won't be able, he'll be able probably to report, and that's it.
Okay,
I mean, he can't hold a job, and he's got a, aunt who helps him, and she's the payee for him.
you need to go.
I mean, this is really just a situation where he was at Georgia Tech, and they found out he was kind of harassing. Which, probably was. And then he was gonna be arrested, and then he spouted off to the police officer.
It was.
He doesn't have a great record.
All right.
Yes.
Superior Court of Fulton County 11th District is now in session. The Honorable Judge Charles M. King is presiding.
Please be seated.
Oh, you might be. Yeah. I think so. Yeah, he is. I saw him do that. He jumped over that.
Judge.
Yeah.
Position 7,
Yeah.
Courtney Brown. He actually, I put him on here. I shouldn't be, maybe next after, we can hold off on putting him in. So, well, I'll let you know things they want.
Who wants to hold off on putting on account?
Yeah, they have some, they need to be on state contacts. He was not supposed to be on this couch. But, they certainly can talk to them. We may
So
try to do a plea. It's fine, we can just wait. till-
we'll hear what they have to say.
And what's the other one that you said you,
Uh,
was it 14? Position 14?
number 14, Niagara Reeves.
Which one?
Niagara Reeves.
Which position?
14.
Well, it's not on mine, but really?
Oh, you know, you just printed yours out?
Yeah.
Okay. I take her off.
She already took it off. Mine is that updated. Mine is basically like a computer screen. Okay. Okay, so this is the final plea calendar for January 8th, and we will just roll through this and take quick announcements. Position 1, Danny Favors.
Mr. Favors is in custody. If you recall, this case was, I believe, on the last final plea calendar. Just as a refresher, Mr. Favors has 2 pending indictment cases right now. One of which is noted on this calendar, both of which are for drug trafficking offenses, so more serious than this case. I discussed it with Ms. Simmons. It sounds like one of those may be indicted shortly and the other one may be able to be accused without indictment. But I think we're still waiting. I'm gonna still be waiting on discovery on one of those cases. There's a 22 CP case. It's one of the cases. Mr. Favors has a private attorney on that as well. So I think hopefully we're looking for a global resolution on everything. But just given the fact that the 2 unindicted cases right now are more serious, I would ask for us to hold off on this based on today's calendar. He's not being held in custody on it. And I think what we're requesting is for a period of about 60 days to be reset. That way on some the new case, the new arrest, the 23 CB case, I guess we feel more confident for 60 days for potentially the drug labs to get back on that.
Who has it with the state? Is it?
Yes, Your Honor. Audrey Simmons for the state. Mr. Clark is correct in that regarding our discussions.
I mean, you're good with the 60 days?
Oh, yes.
Okay,
Yes.
that's all I was checking on. So, yeah, so we'll reset it for 60 days then.
Thank you, Judge.
All right. All right, position 2, Duckworth.
I am present on that, Your Honor. I think at the last point, the state was trying to get transcripts rather from the civil case. I'm not sure what the status of that is, but I know we're on for the 17th and we're ready for trial.
Ms. Clark.
Good morning, Your Honor. Eddie Clark for the state on this case. The transcript apparently is not ready according, when spoke with the court reporter last on January 4th, she indicated that she needed an additional 30 days to complete the transcript. So we'd be asking, Your Honor, to continue the matter until about 45 days, 45 to 60 days.
So we continued it October 11th for this. Let's see where it is on the calendar.
Yeah, October 11th.
Not me, it's IT. Taking a long time. Let me circle back to this one just to make sure we've still got something on the calendar since we've already given 90 days for those transcripts. All right. All right. Position 3, Rhodes, Corey Rhodes. Wait. Yeah, we've got Woods and Rhodes. All right. Position 3. Where's Bumpus?
Stand by, Judge. I'll get her on the line.
And Woods is in custody as well?
Yes, sir.
Who's representing Woods? Where's his attorney?
Says Baxter.
Well, I know what it is. All right, we'll circle back to these two attorneys not present.
Judge, can you just tell me what Miss Bumpus's client's name is? I'm texting
Sure,
with her now.
Corey Rhodes.
Okay,
It looks like Woods has a number of cases. Brown, what about Joe Lewis Brown? Where's he?
I'm looking through stuff. So it looks like for, those were the Division 5.
Yeah.
Division 4,
Yeah.
Mr. Baston, filed a conflict for today, and he filed that before. So, and for,
Well, let's.
looking for Mr. Brown. And I see anything.
Bastion's got a leave of absence in here as well. All right, we'll let him know he can do his final plea on February 17th then before the trial. We'll circle back on that. And what about positions 5 and 6 with Joe Lewis Brown? Do we know where his attorney is? See if you can track him down and we'll circle back. We'll bring him out later. Position 7, Courtney Jamal Brown.
President, Your Honor. I guess may defer more to the state on this, but they have filed a 404B motion Thursday that I've received. We'll have to have a hearing on that. It's discussing with the state. It sounds like there may be supplemental information or witnesses even added to that. I know the last time we were in court on this a few weeks ago, we discussed, even last week, I think, discussed having a February trial date on this. And then otherwise, I guess I defer to the state, but that's where we're at right now.
Yeah, I know, going through my notes, you were pretty eager to get a trial going, Mr. Clark, right?
That's correct. Obviously, this 404B is gonna, in my discussion, it sounds like it's gonna be a pretty substantial amount of information the state has provided me now.
All right, let me hear from the state on it.
Good morning, Your Honor. Eddie A. Miller on behalf of the state. The state did file their 404B motion on January 4th. According to the court's scheduling order, motions were due on January 4th of 2024. And so we did file that motion. We do anticipate possibly revising that because there are other individuals that contacted me on that day as well. However, I still wanted to file it with the information I had. According to the court scheduling order, this case is set for case management January the 18th with a motions hearing date of February the 2nd of 2024. And so I just asked that the court, that we follow the scheduling order that's already been filed. And I believe this matter will be tracking quite along. I do anticipate requesting especially set date, given that some of our witnesses are out of state. And so we will have to file interstate compact paperwork in order to make sure that we're able to secure their presence as well, Your Honor.
Well, I'm trying to follow this here. So, we've got it scheduled for trial on the 17th, right?
Well, we're speaking with the litigation manager. According to the schedule order that was filed, it is set for case management on January the 18th with a motions hearing date of February the 2nd.
I guess it won't do much good doing the motions after the trial, huh?
Okay.
Mr. Clark?
I mean, I'll defer to the court. Obviously, I do want the case tried, given the amount of time he's been in custody, but also candidly, the amount of information that I'm gonna have to investigate with regards to these 404B witnesses is, it sounds more substantial than just one person.
Okay.
So it puts me in a position of saying I would be ready to go to trial on the 17th, not asking for a continuance, but I also don't want to be put in a position where I'm not prepared when I get here on the 17th, so.
All right, let's think this through again. So, Mr. Miller, in your ideal world, what would be the schedule?
Yeah, the case is tracking along quite fine according to the case scheduling order that was filed in December. It's set for motions, was set for case management on January the 18th. It's set for motions on February the 2nd. And then following that, there should be maybe a final plea date and then trial. The state would then, on the final plea date, just ask that the matter be specially set so that at that time we will know if we need to file interstate compact paperwork to secure the witnesses that we need that are out of state. So I think we're
So
fine.
you've got out-of-state witnesses that are in custodies.
No, not in custody, Your Honor. Out of
Okay.
state witnesses that are potentially 404B witnesses.
What?
How long do you anticipate?
How, okay, so I agree with doing the case management and the motions on February 2nd. But let's just say that we agree to specially set it. I always forget on these interstates, what do you need on them? 45 days?
Yes, Your Honor, 45 to 30 to 45 days generally. I've dealt with New York a lot, and generally with New York, 30 days have been a good amount of time for them. So I would say 30 to 45.
19th would be good,
19th of what?
February. Do the motions, Brad?
Through the trial?
Just do the motion.
No, the motions is set for February 2nd, Miller said.
February 2nd, Friday.
But that's what's in the scheduling order. Well, that's all right if it's on a Friday. What? Oh, never mind. It's not for going home early. It's for.
And the only reason I didn't send it, because we got the file on the 29th. That's what the trial, so that's why I put it in there, and I had to change that around.
If the court would provide a date for sometime even early March, then that way I will, with the witness that I have now, I will provide that interstate compact paperwork by the end of this week for the witness we have now currently. This
19th is not a good date.
for motions,
Yeah.
that's fine. 19th is fine.
Are you going to need the witnesses for the 404B motion?
No, unless defense would object to the state's proffering.
I think I would based on what's been provided. Yes.
Because generally the state could just proffer to the court what this witness will be testifying to. I did provide the witness's written statement. It was attached to the motion as well. And then we have a recording of that witness's interview by the state that I'm going to provide to defense counsel later today also.
I mean, it's up to you. I mean, when you're talking about all these interstate compacts and everything else, it just has potential to slow things up a little bit more. But if you want the 404B witness in person, that's your prerogative.
It sounds like if Mr. Miller gets that started today, we'd still be set for February 19th motions, potentially, if she needs to be here in person. The issue is that this is somebody who never reported any of this to law enforcement. So the only thing I have to go on are this written statement and I guess forthcoming audio interview. So in that circumstance, I feel much less comfortable about proffered testimony.
Okay.
And my position on it would be that it's up to the court to make that determination whether or not you're going to accept the proffer from the state or require that person to be here in person.
Well, I mean, if the defense attorney's asking for it, I'm not gonna deny that. And like Clark just said, I mean, the motions day we're looking at ought to work anyway.
19th.
Yeah, so let's do the 19th, and then when can we go to trial? No, I mean, that gives some time to, I think it's probably better because then well, I don't know if it matters now that I think about it because we're talking about witnesses. Yeah, look at that 28th trial date, specially set. All right. And then, spring break. All right, I'll tell you what, let's go with the 19th motions day, and you're going to need to, because we're holding up too many other things right now, but let's circle back around on final plea and a trial date soon, because we're going to specially set it.
Your Honor, to my understanding, that this court may actually have a specially set trial for that same date already.
Which day?
Your Honor, if I can chime in, we do, it's actually on today's calendar for final plea, it's Niaja Reeves, and the state does anticipate that trial will be going. And it also has interstate compact, which is why it's specially set.
Good. All right. That's why there's just no, let's motions down to 19th, and then you sit down when we're done, and let's come up with a specially set trial date that doesn't conflict with another specially set trial date and a final plea day. Are you good with that? All right.
Thank you.
All right. What about position 8? I see Mr. Apton here. Ba.
Good morning, Your Honor.
Mama
I
do
expect
ba.
That's gonna be a plea today.
All right.
I need to speak briefly with the state, my client, and then I'll report back to the court if that's okay.
All right. Is that your case?
It is, Judge.
And you expect that as well, or?
Yeah, based on what he just told me. It's gonna be a plea today.
All right. Oh, yeah, that's right. All right. So position 9, Lafargue.
In custody, Your Honor. Yes, Judge, and I'm here on that case as well. I've reached out to defense attorney Patrick Brantley by email and text and phone last week. Not yet heard a response, so I cannot provide an update on this behalf.
Yeah, I was gonna say, he should be here. Well, we'll get to Miss Bumpus when we roll back around, but I mean, we got a lot of things going on. We can't drop everything when Miss Bumpus gets on.
Wait, what happened? I didn't say anything. I'm just here.
My litigation manager is looking out for you. All right. I mean, I see my notes on it. We'll wait till we hunt down Brackley.
Yes, sir.
All right. Position 10 and 11, Michael Kenny.
In custody, Your Honor.
Good morning, Judge Scott Drake for Mr. Kenny for Tracy Drake.
Yeah.
She's ready.
ADA Willingham on behalf of the state for position 10.
Yeah.
And I expect that whatever happens with position 10 will dictate position 11. I know that's gonna be ADA Simmons, but the state's ready.
And we've got this one specially set, right?
Correct, Your Honor.
That's
Mr.
correct, Your
Drake?
Honor. That is correct, Your Honor.
All right, we'll bring out Kenny in a minute, and we'll bring him out in a little bit, but everybody's ready to go to trial, right? I mean, this is number 1 on the trial calendar.
State's ready. I did want to, make sure Mr. Drake, and Ms. Drake are aware that we will have to, expedite, ballistics report. We have to get it retested. Unfortunately,
And I'm not sure if he can hear you being on Zoom. Can you hear Miss Willingham,
Sir,
Mr. Drake?
I can hear. Yes, sir.
Okay, well, he could hear you, so.
Unfortunately, our ballistics expert who originally tested this, and that report I do believe was provided to, Ms. Drake, is not able to testify. He's currently unavailable, for medical reasons. So at this time, we are trying to get that expedited to get that report redone. But once I get it, I will immediately send it over to defense counsel.
You hear that, Mr. Drake?
Sir, understood.
Why don't we go ahead and bring out Kenny right now? Let's bring him out. This is for February 17th or 18th is the jury trial. I can't remember. January, I meant. 17th, all right. Let's go up to the podium there, Mr. Kenny. Your attorney, Mr. Drake, is on Zoom. Mr. Drake, are you still there?
Sir.
All right, so this is 18 SC 160680 and 21 SC 178384. Michael Kenny. Like I said before, your attorney, Mr. Drake, is by Zoom. If you have any questions or concerns that you want to speak to him privately about, let me know and we'll arrange for you to speak to him privately, okay?
Okay.
Do I have your permission to just go forward with this proceeding while your attorney's on Zoom?
Yes, sir.
All right, so we were just talking about the scheduling of your case. I don't play hide the ball. This is specially set. This is the number one. This will be the number one case in the trial calendar next on the 17th. Mr. Drake, has there been a plea offer extended to your client?
According to Mrs. Drake, there have been several plea offers that have been extended to Mr. Kenny and communicated to Mr. Kenny, and he has rejected them at this point.
And Ms. Willingham?
And Your Honor, yes, the state would like to put the state's final offer on the record and acknowledge that it will be revoked after today. The current offer on this case is 20 to serve 15 years. Should the defendant reject that offer, the state has also filed a recidivist notice and the defendant would only be eligible for life without parole after conviction.
So you're saying coupled with the recidivist notice, if Mr. Kenny goes to trial and if he's convicted, I wouldn't have any option other than life without parole.
That is correct, Your Honor.
Okay. All right. And Mr. Kenny, you reject that offer?
I do.
And we're really discussing the 18 SC 160680, the murder and felony murder case.
Okay.
Obviously this 21 SC, the obstruction case, is riding along with it, but that's the big case that we're discussing here. How much time do you think this case is going to take, Ms. Willingham?
No more than a week, Your Honor.
When you say a week, I mean, what does that mean? Does that include voir dire? Does that?
Yes, that's from jury selection to I would hope a verdict would take no more than a week.
Okay. And Mr. Drake?
Agree, Judge.
Pardon me?
Well, we agree.
Oh, you agree? Okay. Should take a week. Is there anything else? Any other outstanding issues? You mentioned the ballistics report.
Yes,
Why
Your
don't you say it again now that Mr. Kenny's out here, just so he's informed of it?
Yes, Your Honor. The state has previously turned over a ballistic report. However, our ballistic expert is not available to testify. So we will be having that redone and we'll expedite that. And that will be turned over to defense before we start trial.
Okay. Anything else outstanding?
Yes, sir.
You ready to go to trial, Mr. Drake?
Yes, sir.
Okay. We will see you next week then, Mr.
Thank you,
Kenny.
Judge.
You're excused and you're
Thank you.
excused as well, Mr. Drake.
Thank you.
All right. All right, position 12, Simpson.
Mr. Simpson is present, Your Honor. He would be standing on his not guilty plea. I believe is what we previously announced. I think Ms. Clark was present. Is going to be the ADA on the case. I would note I was served discovery in August. I had made the announcement at a previous calendar. There's still an outstanding written statement that we're missing. Other than that, we still have not been communicated a plea offer in this case. All Mr. Simpson would like to do today is stand on his not guilty plea.
Who has this case? Is it Ms. Clark who has it now?
It is, yes. And I did see her here. Just a moment.
All right, Mr. Simpson, we're going to have to wait till she comes back because I've got some questions for her about your case. Position 13, Ajay? Ajay? Okay.
Ajay, yes.
Ajay.
I'm Attorney Carlos Much. I'm here for Judy Kim, who stuck down in Clayton County. We have a plea. We were all signed up, and he's ready to
You ready for a plea?
face immediately.
Okay. That's all I need to hear. Thank you. Position 14, Bagneres. Bagneris. Ms. Jones.
Yes, I am present on that, and she is codependent with position 16.
Who has this with the state?
Morning, Judge. I'll be handling those two cases.
Has there been any, I mean, at least on Bagneris, has there been any discussions about offers or anything?
An offer has been made, Judge.
Ms. Jones?
Life?
It is.
Oh, okay, yeah. I guess the life offer was extended.
Okay. And Mr. Harvey's not, he's conflicted all day today. All right, we're gonna have to reset it. Let's reset it for 60 days.
With that, Your Honor, may my client be excused.
Yep, you're excused.
And Judge, my apologies, I think I have an older calendar, but I know the victim's mother is present on, the original calendar had position 14 as Niaja Reed. I know that case is especially set for February 28th, but as I mentioned, the victim's mother is present on Zoom.
Yeah. I'm having trouble finding Reeves on here. Oh, you took Reeves off. Okay.
Yes, but Your Honor, because it was on the previous calendar, I did at least, the victim's mother is present. So I wanted to at least make sure that I acknowledged her during this hearing. It has been specially set for February 28th, it's my understanding. So I don't think there's anything left to do on it.
Okay. Why did we take it off? Just only because she's out February 28th, is that why? Okay. All right, but as far as you're concerned, I know Mr. Kendrick's not here. You think it's good to
Yes.
go?
State's ready on it. Yes, Your Honor.
Okay. All right, thank you. Position 16, Yoka Lewis. I know.
Yes, I'm here.
You're there? I see Yoka Lewis there. How about Miss Rockwell?
Good morning, Judge. Thank you so much for the platform. We appreciate it. Judge, there's a co-defendant on that, and that's Mr. King. He's present too, I think. This is more about not about a plea, Judge, or that we could work out or how close we are. I'm gonna ask for another final plea, and just because we are in recent receipt of a number of new witnesses. I'm in conversation right now with Mr. Whitenauer, and I just don't want to move this off of a final plea with a number of new witnesses on a homicide case. We're just still needing some information on these extra witnesses, Judge.
Now, who is she co-defendant with again?
Nikita Thomas, I'm here present.
Kimani King here for Nikita Thomas, Judge. Good morning.
Good morning, Your Honor.
When do we have this scheduled? Do we have this scheduled for trial on the 17th? For when? I mean, the only thing, Miss Rockwell, is what you told me was word for word the exact thing you told me on November 27th.
I knew you were gonna say that, Judge. I was ready for it. But it's not like this is a 3-hit throwdown. You know what I'm saying, Judge? This is a homicide case, and it sounds like y'all got a lot going, plenty to do. You know, I said that one time to Judge Wendy Shoup. She really didn't think that was too funny. But anyway, y'all think y'all can take us off of this trial calendar so we could get just a little bit closer together on this witness list, Judge?
Give me 1 minute here. We don't even have it now for a trial.
Well, that's the best news I've heard all day, so let me, I'm gonna be quiet while I'm.
But I'm
ahead.
glad you reminded me, so we'll get it on there as quickly as possible, Miss Rock.
We'll be ready by March of 25.
Yeah. Well, I see Mr. Whitenauer standing there. What do you have to say about it, Mr. Whitenauer?
Thank you, Judge. Your Honor, offers had been extended to both defendants on voluntary manslaughter. Both defendants rejected those offers, and the state has withdrawn those offers based on those rejections. The state did, when this was last on a trial calendar, provide its witness list under the 10-day period. Ms. Rockwell did ask for some more information about some of those witnesses. I've obtained that information, and I will update her and Mr. King with that information. The state is ready for trial and ask that this be placed on a trial calendar.
Mr. King, what do you have to say about all this?
Judge, I would really be concurring with Ms. Rockwell regarding the witness list. And I understand it was provided in November, but the current information for the witnesses was not updated. And we did have a conversation before. So I would just ask for this to, maybe next month or the month after, subject to leave, to be on a calendar if Mr. Whitenauer is representing that everything will be completely updated, like today or this week.
So the state will comply with the statute requiring the provision of the witness information 10 days before trial. If I can get to it this week, I will, but I do now have that information.
All right. So all joking
okay.
aside about this, when Rockwell and King, when would you be ready to go to trial on this?
Judge, could the court give us a trial date, but give us still another final plea?
Well, I'll
Because
do that, but I'm asking you, do you
Well,
need
it's gonna
30
it's
days,
gonna
60
depend.
days, 90 days, and then we'll come up with a trial date.
Okay.
I would ask for
So
60 days, Judge.
All right, you want 60?
Yes.
Rockwell, are
Well,
you good with
that
that?
would be what I would say.
that's perfect, Judge.
All right. We'll do a 60-day continuance. Well, I guess it's not even a for the final plea. And will you schedule a trial? And schedule a trial.
Thank you,
Thank-
Judge.
All
Judge,
right.
may I be
Thank you,
excused
Judge.
quickly to another courtroom,
Yeah.
and then I'll return for for what is anticipated to be a plea?
Yeah, that'll be fine.
Thank you, Judge.
Thank you, Judge.
May I be
Happy New
excused,
Year.
Your
Thank
Honor?
you so much, Ms. Robinson. Thank you, Mr. Whitenauer, Mr. King.
Thank you, everyone.
All right.
Thank you.
So you'll schedule a trial as well, Kathy? So Lewis, if they're not already, Lewis and Thomas are excused as well. All right, 18, Blackwell. Kenneth Blackwell.
I am present on that, Your Honor. He is finally competent, and so I'm talking to the state and hopes to resolve that, so if we could circle back.
All right. All right, now which one did Bumpus have? She's got position 3, Corey Rhodes, co-defendant with Woods. So where's Bumpus? You on?
Yes, Judge.
Oh, we have 4 more positions? Good Lord, that's the oddest thing. Sometimes, oh, wait a minute, I found it. Never mind. Sorry. That's strange. Yeah, you know what happened was there was a blank page. So position 19, Octavian Williams. That's right. We did a plea for Williams. Yeah. Yeah. Wait a minute though. What about, where's Blackwell? I've got Latrice Bennett.
Blackwell was number 9, position 19, Judge.
I don't see Blackwell. Oh, yeah. So we did Blackwell. We're circling back. Yeah, okay. Yeah. Y'all are gaslighting me up here, you know. It took me a year to figure out what that means, so. Position 21 and 22, Latrice Bennett.
Ms. Bennett is present via Zoom, Your Honor.
I'm here. I'm trying to get my camera on.
Position 22 and not 23 is driving the train on this particular case. I do have an offer on position 23, but 22, the current offer is a 12 serve 5, which my client has rejected. In speaking with the state this morning, they indicated that they're open to further negotiations, and I'm happy to do that. But at this point, we can just leave it on the trial docket.
Gordon Simmons for the state, Judge.
So you're both ready to go to trial?
Yes, Judge.
Yes, sir.
Okay. All right, Ms. Bennett, do you hear that? All right, well, we'll leave her on the trial calendar. All right, now we'll go back to Ms. Bumpus and Corey Rhodes. Where's Ms. Bumpus? I think you're on mute, Ms. Bumpus.
I'm here, Judge.
Okay, so they're position 3 and 4 on my calendar. Joseph Woods, you're present by Zoom.
Joseph Woods.
Pardon me?
I have Joseph Woods.
You have Woods. All right. So we've got you scheduled for trial on jury trial. All right, let's go ahead and bring out Rhodes and Woods.
Your Honor,
He's got another.
if I may.
Yeah.
With respect to Corey Rhodes, he has 2 other open cases, both of which are before Judge Ingram. 23 SC 188823 and 23 SC 18826. The counsel of record for those cases is Annette Green.
All right.
But he also has open cases before you, so I had no idea those cases.
23 SC 188823 and 23 SC 188826.
Those are both fresher cases.
Yes, I think this case is older in time, Judge.
And we have the case that we did the hearings on last week that were set for trial on the 26th, I believe.
Now we're set for trial with these on the 17th.
Yeah, I see that. But we have the armed robbery gang case that's set for trial.
Oh, yeah. I forgot that he's in that one as well.
Yeah.
I think we're just dragging on the other one. We're kind of following, but the armed robbery cases are the ones that are really being targeted now.
Yeah, that's what was pretty much, we were trying to see the outcome of that. Have been waiting on a global offer. I don't think we received one.
All right, so which one is Rhodes and which one is Woods? Your Rhodes, your Woods? Okay, so this is 23 SC 185699 Rhodes and Woods. Mr. Rhodes, your attorney, Ms. Bumpus, is on Zoom. if you have any questions or concerns, we're really talking about procedural stuff right now. But let me know and we'll figure a way for you to be able to speak with her privately, okay?
Okay.
Do you have your permission to do this
Yes, yes,
by Zoom here?
yes.
And then we have Mr. Woods, who is accompanied by his attorney, Mr. Bastian, in the courtroom. And who has this one with the state?
That's my case, Judge Audrey Simmons for the state. And with regards to Mr. Woods, he also has 2 other cases.
He does, yeah. So he's got a 22 SC 184. You talking about positions 5 and 6 or other cases beyond that?
Here's a 23 SC 1888400. Is this before Your Honor?
No.
No, Your Honor has the 369 case.
Your Honor has a 369 case, but here's another case, 188400, 23 SC 188400.
Okay, so it looks like this is a bit confusing here, to say the least.
And his attorney for that case is Joe Brown.
Well, that's what I was going to start with. So, Mr. Woods, you've got Mr. Bastian as your attorney for this case, and you've got Mr. Brown for some other cases. Is that correct?
That's correct, Your Honor.
Okay.
I've been dragging, and every time this comes on, we always say, okay, you know what, this case is probably just gonna drag on, but they have to figure out what to do with the case where Mr. Brown represents them, which is the 9 case, the armed robbery. So if it's gonna be tried, the armed robbery is gonna be tried in instruction, and then we'll probably come later with something.
All right. And Ms. Bumpus, you've got Mr. Rhodes for this case, and you've also have it for the multi-defendant case that we've got teed up for the end of January, correct?
Yes, Your Honor.
I think probably, unless defense objects, the best solution with these are to reset them, figure out who has what cases, because we may have some more cases coming to us from other judges.
And no, Judge, I think that's a different Corey Rhodes. That's
Well,
not the
that's a
same
different
person.
Corey Rhodes.
Yeah, I know for a fact because they both are my clients.
Okay, so
They just have the same name. One is Corey K. Rose. It's not even possible. The offense day is 12/10/22. My client was in custody.
all right, well, at least that makes it a little less complicated. So we've got this trial, the 17th. But then we also have Woods, and you're saying, Mr. Bastian,
Yeah, the one that's.
that the big case, the 22 SC 184369 is the one that
But
everybody.
that's really going to be tried.
Now, where is Mr. Brown? I mean, I know you're not his keeper. I know you're not his. Do you know where your attorney is?
I never seen my attorney. I've been here 2 years. I don't even know what Mr. Brown looked like.
Well, how did you originally get hooked up with him?
I think I came to court one time and nobody came to represent me there. And they appointed me a attorney from the court.
I mean, I wonder if is he part of that C3 program we did?
Mr. Brown is.
He's the senior.
I worked with him on other cases.
Yeah.
He's typically appointed via conflict, so I'm in here. Cause I know he was here last time. I don't know if he was on this case, but.
I know he appeared sometime.
Okay.
So I get it. You've been sitting in jail for a while, so you're frustrated, and I get that. And I'm only cutting you off because I really don't want you to say too much, not being represented by Mr. Brown present. But I get why you're frustrated. All right. Well, let's reset this case, and let's see if we can track down Mr. Brown. Can you put an email out to Mr. Brown? All right, and y'all are excused.
And Your Honor, are we gonna reset this for, do you think it'll be after the trial date of the armed robbery?
Oh, yeah. That's what I have in the back of my
Okay.
mind to try to
Okay.
get through that first, and then we'll circle back around. And this is unrelated to you, but to try to find Mr. Brown, who's representing Mr. Woods on 2 other cases. So
Okay.
is that your only?
Yeah, that's my.
All right,
Yes,
so you're
sir.
excused. All right.
Thank you, Your Honor. Happy New
All right.
Year.
You too. All right, is that your only one, Miss Bumpus?
Yes, Judge.
All right, you're excused.
Thank you.
All right, is there anything else that we need to discuss before I take a break?
Yes, Your Honor. Mr. Simpson, who was position, not sure what number, you have either 11 or 12, Robert Simpson. We had, held on it, as Ms. Clark, I think, was in another courtroom. It looks like she's back now, so.
Oh, yeah, okay. So let's jump to, I have it as position 12 at Robert Simpson.
Yes, Your Honor.
So Ms. Clark, when you were in the other courtroom, Mr. Clark said they're still missing an offer. What's going on with this case?
Position 12.
I have it as position 12, but it's Robert Simpson, 22 SC 181736.
Give me one moment, Your Honor.
All right. It doesn't look like we've got it down for, we just have it down for final plea, right, Kathy? But at least we can get an update on this.
Your Honor, if I could have, during the break, I'll confer with, PD Clark.
That'd be good. Because they've been waiting. I know you're brand new back again, but they've been waiting on an offer for a good bit of time. So,
Okay, all right.
so why don't we just circle back a break? Is there anything else?
Yeah, I would ask, yes, if that's all we need to do for today, if Mr. Simpson could be excused. Otherwise, so he doesn't have to wait around until after break.
Yeah, that's fine. That's fine. I mean, we're really doing it for his benefit. So if you want to pass on or just have him wait when you're done, Mr. Simpson's excused, and we will reschedule Mr. Simpson for a final plea and a trial date.
Thank you, Your Honor.
Is there anything else before I come back? All right.
Oh, yeah. Oh, Mr. Blackwell, we're still talking about that. Oh.
Jay? Your Honor, on, Jalen Duckworth, you had said we were gonna circle back on that.
Oh, yeah. Yeah, Duckworth. Let me look up Duckworth real quick. I didn't say anything yet on it. You start to take notes down and you realize you're writing the same exact thing that was written down 3 months earlier. Duckworth. So getting back to Ms. Jones, what are your thoughts on this, on Duckworth and the transcript?
My client's out of custody. We are ready to proceed, but if the transcripts will be helpful, my client was found not liable in regard to this particular matter.
All right, I'll do a reset for 45 days, but that's it. You gotta, I don't know what it's gonna take, time and a half or whatever, but get the transcripts done in 45 days. All right, Ms. Clark?
Thank you, Your Honor. We'll be ready to go. Thank you.
Okay.
Thank you,
All right.
PD Jones.
So let's reset it for another trial calendar, okay, Kathy? Beyond 45 days, final plea date, then trial count. All right, and so we have a final plea that's ready to go right now. A negotiated plea, I mean.
Now, Your Honor.
Which position is that? Do you have the paperwork? As long as we got the paperwork, I'll do it now.
All signed by. Right hand from me. You will swear and affirm that the testimony that's about to give your court, true false, you cannot but the truth so help you.
Yes.
Okay, put your hands down. You may now state your full name and spell it for the court record.
Our full name is Olumide Isaac Ajayi Jr. Solumidei and Ajai. Jr.
Mucha?
Mucha, yes, Your Honor.
You said Carlos Mucha?
Carlos Mucha, sir.
Who's doing this for the state? It's me, 88 Willingham.
And it's Illumidi Ajay?
Ajayi, yes.
Is that correct? Illumidi?
Ajayi, yeah. It's you can say it two different ways. Ajayi or Ajayi.
Okay.
Yeah.
All right, so this is 23 SC 187249, Illumidi Ajay, who's present in the courtroom with his attorney Carlos Mucha, did you say?
Yes, Your Honor.
And we have Miss Willingham with the state. And Miss Willingham, you have a negotiated plea to present?
Yes, Your Honor.
Go ahead, Miss Willingham.
Please state your age and your date of birth.
31 January 26, 1992.
Are you now under the influence of any medicine, drugs, or alcohol?
No.
How far did you go in school?
Bachelor's degree?
Can you read and write in the English language?
Yes.
Have you had the opportunity to review the document that charges you in this case?
Yes.
Do you fully understand the nature of the charges pending against you?
Yes.
By pleading guilty today, you are giving up certain rights. The right to a trial by jury, the right to be presumed innocent, the right to confront any witnesses that may testify against you, the right to subpoena any witnesses for your defense, the right to testify yourself and to offer any other evidence in your defense, the right to have an attorney to assist you throughout the trial proceedings, and the right to not incriminate yourself. Do you understand these rights?
Yes.
Do you understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on these charges by jury?
Yes.
The negotiation in this case is that count 1, aggravated assault with a deadly weapon, family violence, would be reduced to battery family violence misdemeanor under 16-5-23.1, subsection F, subsection 2, and that count 2 of this indictment, possession of a firearm during the commission of certain felonies, would be null pros. You would have a sentence of 12 months probation. You would be required to complete family violence intervention program, have no contact with the victim, and it is my understanding that you've also completed some community service.
Yes. I did 26 hours community service.
The 26 hours of community service, you would be given credit for that as part of your sentence as well. And then it is my understanding that it has been negotiated that this case, that your probation would terminate upon completion of your family violence intervention program. Is that what was explained to you by your lawyer?
Yes.
You're pleading guilty today to battery family violence misdemeanor, which has a minimum of 1 day and a maximum of 12 months. Are you now serving any other sentence in confinement, or are you on probation or parole for anything, anywhere?
No.
You heard me tell the court what the negotiation is in this case, which is 12 months probation. Do you understand the court is not required to follow that recommendation, but can sentence you up to the maximum sentence permitted by law, which is 12 months in custody?
Yes.
Do you understand, however, that if the court does not accept this negotiation, you have a right to withdraw your guilty plea today?
Yes.
Should the court sentence include a period of probation, you will be required to obey both general conditions of probation and special conditions of probation. You will be required to follow the general conditions of probation that probation will give to you when you meet with them, including, but not limited to, that you are not to violate the criminal laws of any governmental unit. Under the special conditions, as previously discussed, you would be required to complete family violence intervention program, have no contact with the victim, and you've already completed the community service portion of this case. Do you understand that a violation of any of these conditions could lead to a revocation of your probation?
Yes,
Are you entering your plea of guilty with an understanding of everything we just talked about?
yes,
Has anyone used any forced threats or promises which caused you to plead guilty against your will?
no,
Are you satisfied with what your lawyer has done for you in this case?
yes,
Do you have any more questions for your lawyer before we go on?
yes.
Yeah, can I tell her what he
Yes.
He said that 12 months probation, and he also heard terminate at the end of the family violence program. You're expected to have that done before 12 months. Once the family violence program is complete, probation says you've completed it, probation would terminate.
Yes, and then the classes I already took.
Yeah, when we spoke to probation, she would look at the classes you took and she would give you credit for those hours you've already taken.
Yeah, I'm good.
Has he already taken hours?
Yeah.
Yes, Your Honor. And he has-
16 hours domestic violence, 16 hours on aggravated anger management classes.
And normally, just so, because it's come up, I normally like a date certain for these programs to be finished, but since the incentive is for you to get it done and be done with it, I'm not gonna, I never, it didn't, I'm not planning to ask about it, but go ahead. Ms. Willingham.
Have you understood everything I've asked you so far?
Yes, ma'am.
Understanding all of your rights, do you wish to enter a plea to this charge today?
Yes, ma'am.
Is your decision to plead guilty made freely and voluntarily?
Yes, ma'am.
Did you in fact commit the offense to which you are pleading guilty? Are you entering your plea of guilty pursuant to North Carolina v. Alford, meaning that you may not admit guilt to every element of the crime charged, but believe it's in your best interest to plead guilty today?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
If you wish to challenge this plea for legal error, you have one of two ways to do it. Your lawyer can explain what these ways are and how they work, but I must advise you of some time limits. The first way is a direct appeal. You have 30 days from the date the sentence is entered to file this appeal. The second way is a habeas corpus petition. You will have 12 months from the date the sentence is entered to file this petition. Do you understand these time limits?
Yes, ma'am.
Sorry, Your Honor, one moment. Should this case proceed to trial, the state would prove beyond a reasonable doubt that on June 12th, 2021, Corporal Williams responded to 2107 Creel Lane in reference to an information for officer call. Upon arrival, officers met with Ms. McCora, who advised at or around 500 hours this morning, she went to her child's father's residence to retrieve their infant son they share and spent time with together. Ms. McCora stated during that time, both her and her child's father, who she identified as the defendant, who lives at 6219 Lamp Post Place, Atlanta, Georgia, which is where the incident originally occurred. Ms. McCora stated that both parties got into an argument about their infant son. She advised that the defendant stated he was going inside the residence to give her the child. She advised that when the defendant came back to the front door of the residence, he had in his possession a loaded firearm. Ms. McCora advised that he raised the gun from his waist to her face and started to threaten her with the weapon and inform her that she will not leave his residence with their child. Ms. McCora stated when she began to leave this residence, the suspect told her he had something for her and told her he would kill her and pointed the loaded firearm at her, placing her in fear with a deadly weapon, which could cause seriously bodily injury or result in death. The victim informed the officer that she fears the suspect, that she is in fear of the suspect and was scared to call the police for help. She advised that at the request of family members in North Carolina, that she contact police for help. And nothing further. Your Honor, I had an opportunity to speak with Ms. McCora, and I do believe the ADA who negotiated this plea, Abigail Potter, spoke with her after that. I'm looking for her notes, but in my communication with her, I know that she did not want to proceed forward with the case. it, what I explained to her was a felony probation offer, which is why I just want to go back in and confirm. I do know that when I spoke with Ms. Potter, she did say that she spoke with the victim. I just wanted to be sure before I stated on the record that she is aware, but either way, she didn't want to move forward. So I'm sure that she's fine with the misdemeanor offer.
All right, Mr. Mucha.
Oh, well, I should say it goes without saying, I think that my client did not wave a gun, threaten to kill someone. The state is null processing the weapons charges. There was an altercation, and he accepts that he should have dealt that in a calmer, more adult way, and that's why he is pleading guilty to a misdemeanor charge. He's a college graduate, has had no trouble with the law. He's a plane hander at Delta. It's actually it has an Air Force enlistment that is sort of on hold while this is going on. So that's why we're happy to get a misdemeanor plea. He is eligible for first offender. We'd ask that he would give first offender status, and upon completion of probation, have the record sealed. Of course, I told him Uncle Sam will see everything when you go into enlistment, but it'll show that you don't have a criminal record when you go in.
So you want to do first offender?
Yes, sir.
Ms. Willingham, isn't there?
No, Your Honor, the state has no objection. And for the record, I did want to add that although the state is asking for no contact, it appears from Ms. Potter's communication with the victim, she stated that she is good with the misdemeanor offer. She's currently living in Texas, and she wanted to be able to start co-parenting with the defendant. So she actually wishes that there was no violent contact, but what was negotiated is the no contact.
Yeah, Your Honor, we weren't aware of the victim's statement, but we'd ask that then be no violent contact. He hasn't seen his child while this case is pending, so.
2 years?
Yes.
3 months?
If the victim's willing to communicate with him so they can co-parent, that's wonderful.
All right, so no violent contact. The victim lives in Texas. You said you worked for Delta?
I work for Delta Airlines and Coca-Cola currently.
And you plan to stay in the Atlanta area?
Oh, yes, sir. I do live in Atlanta. I do live in New York. My job brought me to Atlanta, so I'm here.
You know, the only thing I want to make sure you're aware of on the first offender, I mean, they're no processing one charge, they're downgrading it to a misdemeanor, and it's 12 months probation, which, and as soon as you, with an incentive to complete family violence intervention program. But I do think the main thing, have you gone over them, the pros and cons of the first offender, taking first offender?
In short, if you trip up, the judge can resentence you. You could spend the rest of the.
I have no reason to trip up.
Yeah.
I don't trip up.
Well, and really, from your perspective, the only true negative I see in all this is a once in a lifetime opportunity.
Yes, sir.
So you take your first offender this time. I mean, you have a clean criminal record. You're 31 years old. You're eligible for first offender. So I'm optimistic that you won't have a situation like this again, but it is a one-shot deal. You wouldn't be able to take it again.
Yes, sir.
If you take it now.
And his real big incentive is, as you know, Your Honor, the family violence is like the only misdemeanor. You can't handle firearms. And the Air Force recruiter saying the government's not going to give you a gun.
That was a conversation with the recruiter.
Okay.
But first offenders, that issue resolves that. So that's why he's.
Okay. And that's the advantage of the first offender, especially when it comes to job applications. You've got a clean criminal history at that point. Okay. Mr. Ajay, do you understand the nature of the charges against you?
Yes, sir.
You have just heard the district attorney explain all the rights you give up by entering this guilty plea. Is it your wish to give up these rights and have this court accept your plea of guilty?
Yes, sir.
Do you understand the court is not bound by the recommendation or the plea agreement, and I can sentence you as I deem appropriate?
Yes, sir.
Although you are not admitting guilt, you decided it is in your best interest to plead guilty because at trial, the evidence presented against you may be strong. Do you freely and voluntarily enter your plea of guilty to the charge against you?
Yes, sir.
Mr. Mucha, are you satisfied that your client is competent and understand the plea is voluntary and there's sufficient factual basis for entering the plea?
I do, Your Honor.
Okay, the court finds that you understand the nature of the crimes and the consequences of this plea. There is a factual basis for the plea and the defendant has voluntarily, intelligently, and voluntarily entered this plea. The defendant has requested a sentence under the First Offender Act. The court will approve that request, withhold adjudication, and does hereby notify the defendant that this plea may not be withdrawn in the event a defendant fails to fully comply with the terms of the sentence I'm about to impose, which is the negotiated plea. And so the first count, the aggravated assault, will be reduced to misdemeanor battery, family violence. And the second count, the possession of firearm during commission of certain felonies, will be no prost. You'll have 12 months of probation, no violent contact with the victim. You are to complete a family violence intervention program. Upon completion of that program, your probation will terminate. You have 26 hours of community service, which you've stated you've already completed. And I believe that's it. Is there anything else?
Judy Kim was his counsel of record. I'm filling in for. She did tell me this morning that she was going to file a motion of the court to seal the record upon termination of probation. So
Yeah, I'll agree to that. So I assume the state doesn't object to that. All right, you're excused.
Thank you, Your Honor. Thank you.
All right. All right, anything else before I take a break?
Your Honor, that concludes my business for today. May I be excused?
You're excused, Ms. Willingham.
Ms. Willingham.
Have you got by?
I do, Judge. I don't know if there's a final announcement about whether that'll be okay or not. I was in here a moment ago.
He's sitting out there.
All right, let me go see if I can.
I mean, it looks like I've got plea paperwork in front of me.
All right, well, that would seem to indicate it's a plea.
Oh, no. Let me see here. Yeah, he checked guilty and signed it, so.
Judge, do you have the indictment? I haven't signed it.
Yeah. You got me.
No, I was.
If he finishes the judge.
Stand. Do you want him here or here? Does it matter?
It does not matter to me.
Stand right there then.
Whatever's more convenient with the microphone and your.
He is.
We swear in affirm that the testimony that's about to be put to the whole truth and nothing but the truth.
Yes.
You understand that? You may now state and spell your full name for the court record.
My full name is Mamadou Ba. Spell M-A-D-O-U, last name B-A-H.
Thank you. Okay, this is 21 SC 178-675 Mamadou Ba, who's present in the courtroom with his attorney Jay Apt. And we have Mr. John White now representing the state. Mr. White, now you've got a negotiated plea to present?
I don't know if it is negotiated.
It's negotiated.
It's negotiated. All right.
No fine, right?
I'm not asking for a fine.
It's negotiated, Your Honor.
Okay. Go ahead with your negotiated plea, Mr. Whitenauer.
Thank you, Judge. Sir, my name is John Whitenauer. I'm an assistant district attorney with the Fulton County DA's office. I'm going to be asking you some questions, and if you would please answer out loud, yes, no, or as appropriate, so that the court reporter here can take everything down. Agreed?
Yes.
All right. You've already been sworn, so let's go ahead with those questions. Are you now under the influence of any medicine, drugs, or alcohol?
No.
Is there any medication that you normally take that you've not taken today?
No.
And how far did you go in school?
I completed high school. I went to college a year and a half.
Okay. And can you read and write in the English language?
Yes.
Have you had the opportunity to review the document that charges you in this case, that is the indictment?
Yes.
And do you fully understand the nature of the charge pending against you?
Yes.
That is one count of false statements.
Yes.
All right. By pleading guilty today, you are giving up certain rights. I'm going to read to you each of those rights, and then just let me know that you understand that by entering this plea today, that you are giving up or waiving that right, okay?
Okay.
By pleading guilty today, you are giving up the right to a trial by jury. Do you understand?
Yes.
You're giving up the right to be presumed innocent. Do you understand?
Yes.
the right to confront any witnesses who may testify against you,
Yes.
the right to subpoena any witnesses for your defense,
Yes.
the right to testify yourself and to offer any other evidence in your defense,
Yes.
the right to have an attorney assist you throughout the trial proceedings,
Yes.
and the right to not incriminate yourself.
Yes.
Again, do you understand that by entering a plea today that you're waiving or giving up all those rights that I just mentioned?
Yes.
Do you understand that if you were to plead not guilty or remain silent and enter no plea at all, that the state would be required to have a trial on these charges by a jury?
Yes.
Sir, you're entering a plea today of guilty under the First Offender Act to the one count of false statements. You need to understand that that count carries a sentencing range of 1 to 5 years in confinement. Do you understand?
Yes.
Are you now serving any other sentence in confinement, or are you on probation or parole for anything, anywhere?
No.
All right. You are entering this plea in a negotiated fashion. That is, that the state and your attorney are jointly recommending to the court that you be sentenced to 3 years on probation.
How many?
3 years, Judge.
3 years, okay.
I will also be asking the court to impose some certain special conditions, that you have no contact with the victim's family, that you have no contact with the co-defendant, Ricky Lafargue, that's Lafargue, or any of the witnesses in this case, that you not return to Lenox Square at 3393 Peachtree Road Northeast. That is the address of the incident location. That you possess no firearms, that you consume no drugs or alcohol, and I understand that you'll be entering this plea under first offender. Do you understand those special conditions?
So you saying I can't return to the
You
mall?
cannot go to Lenox Mall while you're on probation.
Yes.
Okay. Do you understand that the court is not required to follow that recommendation, but can sentence you up to the maximum sentence permitted by law, which, again, is 5 years in confinement?
Yes.
All right. Do you understand, however, that if the court does not accept this negotiation, that you have the right to withdraw your guilty plea today?
Yes.
All right. Sir, should the court sentence include a period of probation, you will be required to obey both general conditions of probation and special conditions of probation. Regarding general conditions, you'll be required to follow those conditions of probation that probation will give to you when you meet with them, including but not limited to not to violate the criminal laws of any governmental unit. A moment ago, I mentioned some of the special conditions that the state will be recommending to the court. Do you understand that a violation of any of these conditions could lead to a revocation of your probation?
Yes.
Are you entering your plea of guilty with an understanding of everything we've just talked about?
Yes.
Has anyone used any force, threats, or promises which caused you to plead guilty against your will?
No.
Are you satisfied with what your attorney has done for you in this case?
Yes.
Do you have any more questions for your attorney before we go on?
No.
You hesitated, so let me ask you again. If you have
I was
any
just
questions or
thinking.
any questions or concerns, this is the time to address them.
No.
Very well. Have you understood everything I've asked you so far?
Yes.
All right. And understanding all of your rights, do you wish to enter a plea to these charges today?
Yes.
How do you plead to the one count of false statements in the indictment?
Guilty.
And is your decision to plead guilty made freely and voluntarily?
Yes.
It's my understanding that you are wishing to be sentenced as a first offender. Is that correct?
Yes.
You need to understand that there are some benefits and risks to requesting a first offender sentence. The benefits are that if you do what the court orders you to do not violate the terms and conditions of your probation, you will not have a conviction for these offenses. The risks are that if you violate the sentence on your probation, you commit a new offense, etc., the state could ask that you be brought back before the court and ask that you be adjudicated guilty, meaning that you would have a conviction. And then the court can resentence you up to that maximum sentence we discussed earlier, which again is 5 years in confinement. Do you understand these benefits and risks to asking for first offender treatment?
Yes.
Knowing all this, do you still want to be treated as a first offender?
Yes.
Have you ever been convicted of a felony before?
No.
And have you ever used first offender in any other case or in any other place?
No.
All right. Sir, are you a United States citizen?
No.
All right. So you need to understand that pleading guilty today could have some immigration consequences, that it could lead to your deportation from this country. Do you understand that?
Yes.
All right. I also need to make you aware of a couple of time limits. If you wish to challenge this plea for legal error, you have one of two ways to do it. Your lawyer can explain what these ways are and how they work, but I must advise you of some time limits. The first way is a direct appeal. You have 30 days from the date the sentence file a direct appeal. Do you understand?
Yes.
The second way is a habeas corpus petition. For this one count of false statements, which is a felony, you have 4 years from the date the sentence is entered to file a habeas corpus petition. Do you understand these time limits?
Yes.
All right. Do you understand that if you are to be sentenced as a first offender probationer, that you are not allowed to possess firearms during the course of your probation?
Yes.
Do you understand that if you were found to be in possession of a firearm, that you could be charged with another felony, which carries up to 10 years in confinement?
Yes.
All right. Your Honor, with that, I'll turn now to a factual basis for this plea, which is that on March 8th of 2020 at 3393 Peachtree Road Northeast, which is the address of Lenox Square here in Fulton County, this defendant's co-defendant, Ricky Lafargue, shot and killed the victim in this case, Thuan Nguyen, that's Thuan Nguyen, in the back of the head. This shooting was captured on surveillance video at Lenox Mall. After defendant Lafargue shot the victim, he, along with the defendant Ba, as well as several other individuals, fled from that location into a vehicle. They then attempted to navigate their exit from the parking lot in front of Lenox Square, but were unsuccessful, striking a BMW that was parked in front of Lenox Square. The vehicle that those individuals were in came to arrest, at which point those individuals all fled from the car. 4 of them managed to run off the property. Mr. Ba was not able to, as a bystander who also happened to be with the Cobb County Sheriff's Office, was present, drew his weapon, and held Mr. Ba at gunpoint until law enforcement arrived. Mr. Ba was arrested and was later interviewed by detectives in this case after being read his Miranda rights, which he waived. And during that interview, he was questioned about his knowledge of the other individuals in the group. Those individuals were captured on surveillance video, both inside and outside of the Lenox Square Mall, walking together, shopping together, purchasing food together. And although Mr. Ba acknowledged that he had some familiarity with them, he denied knowing them and contended that he could not identify them by name or by other identifying information. The detective in this case obtained, Mr. Ba's cell phone and extracted the data from his cell phone. And in reviewing that data, found on it photographs of one of the other individuals who was captured in the group that Mr. Ba was with, wearing the same green jumpsuit or tracksuit that he was wearing the day of the shooting. Additionally, on Mr. Ba's cell phone, the detective located a cell phone number in his cell phone that Mr. Ba had used on a rental agreement for the car that was being driven by this group that day. So while Mr. Ba contended to law enforcement that he did not know these individuals, his cell phone indicated otherwise, that being the photograph of an individual that he was with that day of the shooting, as well as a phone number being saved into his phone for one of the other cell phone devices that was found in the car. Based on that investigation, the contradictions between what Mr. Ba had represented during the interview and the data on his cell phone, the detective in the case drew warrants for false statements. Your Honor, I would note that this defendant does not have any criminal convictions here in Georgia. This would be his first arrest. He does have a pending matter out of state. I've made his attorney aware of that so that he can address that. But that has not been resolved with the conviction. So it does appear that he is.
Sorry, can you just give us one?
Yes.
That's out of state.
Oh, that's something he told me about some things that misdemeanor or something like that.
What state is that in?
Are you aware? I'll call him, yeah.
Okay.
They say it's.
Sorry, go ahead. Okay, so it does not appear that he has any convictions such that he would be eligible for first offender. The state has no objection to being sentenced as such. We would ask that you follow the negotiated plea in this case, nothing further from the state.
Okay, Mr. App?
Your Honor, it's a negotiated plea. We're asking that you accept it, obviously. We're asking for first offender. Guess since it's only 3 years probation, we don't really need a behavioral incentive date, but if the court in its discretion wants to give one shorter than 3 years, we're certainly happy to take it. Since his arrest, Mr. Baugh has been very cooperative. In fact, the last time we had court before Your Honor, Mr. Wittenauer, myself, and Mr. Baugh met back in the jury room, and Mr. Baugh, reiterated everything that he knew to Mr. Wittenauer. He's happy to, if he's called, testify truthfully at trial. And so we're just asking that Your Honor accept the negotiated recommendation. I do want to just put on the record, I know the court has no power of saying it, but Mr. Baugh is going to be residing in Ohio. And so we are going to ask probation to give him a travel pass and then ask probation to allow him to initiate interstate compact so they can have his probation transferred to Ohio. I also want to get Mr. Wittenauer that contact information so that if he needs to subpoena Mr. Baugh, he can get in touch with him in Ohio. That's really it, Your Honor. He's got no criminal history, and we thank the court. And just for the record, we put that he is 24 years old on the plea paperwork because today is his birthday. He turns 24 today.
Okay. Mr. Whitenauer covered all of the pros and cons that I would cover on the first offender. Just be aware of the fact that you've got probation for 3 years, so you slip up, you could theoretically be sentenced to 5 years. You understand that?
Yes, sir.
In prison. First offender, what about this? All right, Mr. Mamadou, do you understand the nature of the charges against you?
Yes.
You've just heard from Assistant District Attorney Whitenauer explain all the rights you give up by entering this guilty plea. Is it your wish to give up these rights and have this court accept your plea of guilty?
Yes.
Do you understand the court is not bound by the recommendation or the plea agreement, and I can sentence you as I deem appropriate?
Yes.
Are you pleading guilty because you are in fact guilty?
Yes.
Mr. Apt, are you satisfied that your client is competent in understanding that the plea is voluntary and there's sufficient factual basis for entering the plea?
He is. There is. Thank you, Your Honor.
All right, the court finds that you, Mr. Mamadou, understand the nature of the crimes and the consequences of this plea. There is a factual basis for the plea, and the defendant has knowingly, intelligently, and voluntarily entered this plea. Defendant has requested a sentence under the First Offender Act. The court will approve that request, withhold adjudication, and does hereby notify the defendant the plea may not be withdrawn in the event the defendant fails to fully comply with the terms of the sentence I'm about to impose, which is just on the one count for false statements. It'll be 3 years probation, no contact with the victim's family, no contact with the defendant, Ricky Lafargue, no contact with any of the witnesses involved in the case, and you are to stay away from the incident location, Lenox Square Mall. Is there anything else?
Judge, I did ask that the court impose a special condition of no firearms and that he consume no drugs or alcohol.
Okay. No firearms, no drugs without a prescription, and no alcohol. You understand that?
Yes, sir.
So for 3 years.
Yes.
And Judge, I do want to put, I don't know if Mr. Wittenauer went over it, just to perfect the record. Mr. Baugh, you have 4 years from today's date to file what's called a writ of habeas corpus. It's an appellate right you're not waiving. It's a civil action alleging that your constitutional rights were somehow violated at any time. You also have 30 days from today to ask this court to withdraw the plea based on some manifest injustice, or 30 days, or the end of the term of the court for Fulton County, which would be the end of January. to file an appeal, a direct appeal to the Court of Appeals alleging essentially some manifest injustice or constitutional right violation. Do you understand that?
Yes.
You waive all other rights to appeal. You understand that?
Yes.
Okay. All right.
Anything else?
Nothing from the state, Judge.
Nothing from the defense, Your Honor.
All right, you're excused.
Thank you so much, Judge. He needs to wait here for probation?
Yeah.
Great.
This is what's showing. I ran it this morning. If you want to share that with them.
Yeah. You get up November of 2022. Are you in Missouri? Mr. Bach? Can I take a screenshot? Can I take a picture of that?
Yeah, for sure.
I'm gonna take a picture of it.
Is there anything, Tanya or Philip, anything we can take care of now before?
I'm just gonna
Great.
talk about Mr. Rockwell. Yes.
Good to see you, Your Honor.
Good to see you.
I hope
Happy
one of
New
these
Year.
days- Happy New Year to you, and one of these days I'll be down with YSL.
Hey, that's going on right now, right?
Oh, yeah, I got my associate sitting in there as we speak.
I was gonna say, I was gonna jokingly call it out because, Harvey wasn't here because of YSL and you are, so.
What scares me is they're 3 to 5 years after YSL, the backlog that I've built up.
I don't know
caseload
if
is
I've
going
ever
to
gotten a police report.
be an emotionally and physically crushing thing.
All right.
I'm not looking forward to that period of the practice of law.
Well,
All I
I'm
have.
gonna be on trial probably every month for the next, it'll be for 3 or 4 years.
hey, you'll know,
I mean, I'll file leaves, but it's gonna be awful for a long time.
you'll be a master of the craft after that. So.
I don't need to be a master. Have psychological well-being.
All right, all right.
Man,
Judge, may I inquire about, Mr. LaFar, did Mr. Brackley appear by Zoom? Where's he?
Yes. Kathy? Well, I mean, we can't. That's odd that he would just. Should give it, this is a pretty big case. Brackley was difficult to hear from, kept disappearing off of Zoom. We don't have this scheduled for trial date yet?
So Judge, this case, is on, and please correct me if I'm wrong, but, on the January 17th trial calendar. It does fall after a few other cases, but the only one that I understand actually, going forward right now is that, I think Michael Kinney.
Michael
case.
Kenny, yeah.
If that defendant should enter a plea, my read of the calendar, is that this case would be next, up.
Are you ready to go?
Ready?
All right. Kathy, send Brackley an email, say he wasn't here for final plea. We'll take his final plea the day of trial. All right.
Well, Judge, I understand what the court is saying. I think it's important, that, from the state's perspective, its offer, and I understand defense may say that's no offer at all, is life. But after trial, the state would be asking the court, the defendant be sentenced to life without parole, based on facts and circumstances of this case. And so before I go any further, I mean, I do also think it's important that if the defendant is up, he be brought out, so he's at least made aware of what's going on out here, in terms of.
That's a good point. This case is a big deal, and let's bring him out. I'll make sure he doesn't say a word. And yeah, I mean, but this is ridiculous. He's not here, to be frank.
I don't know what happened.
Well, I mean, but I have my notes to last Zoom call. It was impossible to deal with him during Zoom. send him send him an email that we're expecting, he's high up on the list to go into trial on the 17th.
So just phase 4 for me at all times.
All right, this is 21 SC 178-675, Ricky James Lafargue, who's present in the courtroom. His attorney, Mr. Brackley, is not present for the final plea calendar. And we have Mr. John Whitenauer, who's present with the state. I guess I'll ask you, Mr. Lafargue, do you know where your attorney is?
No, I'm not aware of where he's at. I spoke to him like on Friday. He told me that he was gonna be able to come on virtual, I think, but I ain't speak to him ever since then.
All right. Well, your case is scheduled to go to trial on the 17th. And this was supposed to be your final plea today. Like I said, your attorney's not present. So, my plan is, you're high up on the list to go into trial. So if you happen to mention to Brackley, tell him that we're still planning to go to trial with this. And Mr. Whitenauer here, I don't want you to comment on anything because you're unrepresented, but I do want him to at least read the offer that was presented to you and what, if you go to trial and if you're convicted, what he plans to ask for.
Yes, Judge, if the defendant wants to enter a plea, today, Your Honor, I'm now getting a phone call from, his attorney. I just texted him, saying that his client is in court. He's now calling. Would Your Honor like me to answer the call or?
Sure, go ahead and answer the call.
This is John Whitenauer.
Yeah, how are you, sir? Mr. Brackley.
Yes, sir. I'm in court. Before Judge Eaton, your client is at the podium. This is on for a final plea calendar. I think if you are able, the court would like you to join by Zoom.
Yes, can they send it to me? I just finished. I'm in the middle of the trial, but I have an hour. I can do it.
Okay. It's my understanding that you should have received an email with the Zoom link.
All right, let me see. Got a minute?
Yeah.
Judge is indicating yes.
Okay. All right, so can I talk to you outside for a second?
Judge, would you like to recess? It sounds like he wants to speak with the opposite.
Yeah, let's recess. Send, wait a minute, what is, Mr. Brackley, are you asking to talk to Mr. Whitenauer privately? Of course, your attorney, your client, I'm gonna have to step off and we'll have him go back into the holding cell, or what's your request?
Prosecutor for a second, and then we can do the appearance.
Okay. All right, why don't we do that then? I'll step off and you'll, Ms. Jones?
Yes, thank you. I've spoken to the state in regard to Mr. Blackwell, Kenneth Blackwell, position 19. Their offer is going to be served 1 year, community time served. However, the state doesn't have a police report. And it'll be my file. I don't have one either. I just have the arrest report, but I am comfortable just going off, I'm sorry, the arrest warrant. I'm comfortable going off the warrant, and so we would just have to stipulate to a factual basis, and I just wanted to make sure that was okay with Your Honor, otherwise we have to reset this.
Let me find Blackwell on here again.
He's my 19, I'm not sure.
18 on the judge's calendar.
Okay, I see it. Terroristic threats, criminal trespass. Yeah, I'll allow that to be stipulated. All right, let me step off for a minute. Yeah. All right.
No, this is for the other guy. Oh, I'm still working on those.
Just need some paperwork.
Okay.
You're not going to sign up?
It's the 1 year community.
Yeah. And then we're gonna get rid of this whole, that's what I decided.
If you have a kid, it's never.
Well, I think whatever went around this time was just bad. I don't know.
It's supposed to be 90% chance of, icy rain tomorrow.
Yikes.
90% chance. Icy rain.
Oh,
That's like hail.
yeah.
She's saying work from home tomorrow.
Yeah, this is
No, I was-
exactly what I'm thinking. Work from home.
From Miss Kathy, 90% chance of icy rain tomorrow. That's like hail, like hail, original hail.
Yeah, and people in Atlanta
And the
can't
roads
drive,
might be-
so.
And the roads will not be pretty. Nope.
I'm going to the restroom. May I have a second?
Oh, yeah.
Oh, jeez, it's gonna be, 18 degrees next Wednesday. Dang.
But how to drive? This is nastiness you speak of. Do I need to get my weather out or?
Yeah, this is not good.
It's okay. You're doing paperwork or. Yes.
Mr. White now,
Yes.
do you happen to have a, first of all, how are you? Happy New Year.
Hello.
Did I see you?
I don't think so.
Well, Happy New Year. Hope you had a great holiday, you and your family.
Yes.
Always had a good time.
We did. We had a great break.
Yep.
Yep.
Memories.
Here we go.
But, I was wondering, do you have a police report for Mr. Bob? So that I can put it with, since he wants to do iPods, I have to have.
Sure. Yeah.
So if you could send it to me whenever you get a chance, not rushing.
I can. I don't know if I'm not right now. And Kathy, he's signing on right now, so as soon as the judge is ready, we should be seeing him pop up.
Okay, I'm waiting for him.
All right.
Is this the phone, isn't it? Go ahead with it.
I don't think so.
Your offer was right?
It is.
Oh, that was in a.
I'll have to reach out right now.
It looks like Mr. Kenny might go. And if you want Mr. LaFarge.
Yeah. I won't give it to him.
I just wanna make sure. Swallow the.
No, you're not that crazy.
I think the next case after that is the DV murder case.
Right, but that's like the set in February is my understanding.
It's supposed to be after that, sir.
Yeah.
Could you just give me copies? Shoot me a copy of it, because I just need it. His sentence. Boss, yes. Because I'm sending him, hopefully he'll be able to get into the office tomorrow, so he can go ahead and get his iPod transfer. Okay. No problem.
It's a little
It's a little cold, isn't it? Yeah. Oh, yeah. I'm not complaining because I prefer it to be cold rather than.
Yes, yes, exactly. Oh my God. Happy birthday, son. Thanks. What's it supposed to get down to tonight? I know it's supposed to rain, but is it supposed to get like down to 3? Candy?
Yonder, you said a break. That wasn't a break.
Well, yeah, but I got back there. I didn't realize, what was I even taking a break for? I mean, I know Mr. White now needed to speak with, and I know Jones is back there working on our plea, but. So Ms. Simmons, where were you before here?
Before here, Judge, I was with CID working on a special indictment project. And then before that, I was in Judge Edwards'
Oh,
courtroom for a year. And then in between that,
a year. That's a long time. I wish I could have somebody for a year.
and along those lines, Judge, Mr.
Oh.
A.D. Scott, who appeared briefly before you last week, has been reassigned.
Oh, so that's 1 week. That's a record.
So I will be by myself.
If I was,
in the courtroom.
luckily, I'm pretty secure with myself, or I'd start to think it was me.
It's you, Judge.
1 week he got reassigned. Wow.
Gone again.
Apparently somebody told somebody about
Yeah. It's hard to have two people. And I see Christina is back
She's back.
with
in
domestic
sexual
violence,
assault
right? Yeah,
unit.
it was sexual assault. That's right, sexual assault. Yeah.
Your Honor, the head, Dr. Blank fired the head coach of the Falcons yesterday.
I saw that. Yeah.
I
I think that was in the works. I'm not sure anybody was surprised by that. But you know, he is either the wealthiest or will be the wealthiest NFL coach probably ever. His father founded Federal Express. Yeah.
Oh, so he ain't hurting there.
No, his father's worth like $6 billion.
I was like, okay, cool, fine, you know.
I don't think that was his attitude.
You think he was upset about it?
I think he was probably upset, but yeah, his father's Fred Smith, the founder of FedEx.
Really?
Yeah. What are we doing with Lafargue?
Judge, I did speak with him in the hallway over the phone, and he said he was logging on.
Okay.
He's
So-
on.
Oh, okay.
All right, well, let's bring Lafargue back out then. Oh, that's right.
Jones, want to get him time?
You let Jones get her stuff signed.
Wait a minute, hold on. He was on, I thought we were having to.
All right.
I don't know where he went to go.
All right, well, if he's on, great. And if not, we'll do the Jones plea.
Okay, he's back.
Yeah, but it's either bring him out and delay Jones's plea or leave him back there and let her finish. So where does Scott go? What judge? Ms. Simmons, where did Scott go? What judge?
He's going to be in Judge Edwards' courtroom.
Okay.
Okay.
Maybe it is his connection. He's in New York.
Anybody have a guess as to what sound has been playing all morning? Anybody else hearing that?
Somebody a beat.
Yeah,
What beat?
I don't hear it.
all morning it's been going on.
I've been here.
Yeah. Okay.
Okay.
Just make sure.
I remember that you're not hearing things, you know, that.
Okay.
It's coming from over there. I
Yeah.
think it's that thing right there. It's plugged up. It's the long.
So say we know where to get a mental evaluation done. We can. Oh, now I just heard it. Thanks.
Something, it's like someone's cell phone alarm is going off.
Is it outside the courtroom?
No, it's not like it's inside, but there's no phones in here.
Hold on. He was on. Oh, okay. He was on. I thought we were having to.
It's alone.
Okay. Okay. I'm just making sure.
It's not like it's inside, but there's no. There's no phones in here.
Is it Wittenauer or Whitenauer? Is it Wittenauer or Whitenauer?
It's Whitenauer.
Okay.
Many years ago, our family came from the town of Weitenau in Bavaria in southern Germany. And so that's what we say.
I was correct because app calls it Wittenauer. So
Well, I've given up on correcting people.
sign
Call
a
it
dis.
whatever you want.
You know, I think people say Whitnall because there's a jazz.
Okay,
artist, and
all
his
right.
last name is Whitnall.
I'm not classy enough to know that, but
Okay, well, there you go.
all right.
I could see app being into jazz. I could see
That's what
that.
it was, Your Honor.
What?
It's the, it's outside the courtroom, that screen.
Yeah, they've had problems with that before.
That's going off. It's louder than how all of it.
Okay.
All right, so what attorney are we looking for online again?
Brackley's.
Brackley. So Brackley's online?
Yeah.
Can you hear me, Mr. Brackley?
Needs to unmute and.
Unmute, Mr. Brackley. Mr. Brackley, unmute.
Technical issues.
Where's those?
Bad service. Bad Wi-Fi.
Yeah, I mean, if you want to do it by the phone, I don't care. I just doesn't seem like we're.
Happy to give him a call, Judge.
Yeah, why don't we just do it by the phone? Let's get it done with. It's not like he's taking a plea or something. Go ahead and bring out Lafargue again.
Yeah, I can, I'm in, but I can't unmute myself. You want me to-
I understand, it's fine. We've just decided we'll proceed telephonically, so I have you on speakerphone. Judge Eaton is on the bench and they're bringing your client out.
Sure, I apologize, but I can't unmute myself.
Yeah, that's all right. I understand technical. You gonna do it to where the.
I'll just place it with the mic.
Yeah, that'd be great. All right, so we're back on 21 SC 178675. We have Ricky James Lafargue present in the courtroom. His attorney, Mr. Brackley, has had some Zoom issues, so he's just appearing by cell phone. I've allowed it because we're really just talking about some procedural stuff unless something is wildly developed since I took a break. And then we have Mr. Whitenauer present as well. Mr. Lafargue, as I mentioned, your attorney's on cell. He can hear us. If there's something you have to speak with him about that you deem as private, let me know and we'll arrange for you to speak with him privately. Okay.
Would I be able to get 5 minutes with him? If that's okay with you?
Well, let's talk about. We'll arrange for that, but let's first see what your attorney has to say. Mr. Brackley, Mr. Lafargue would like 5 minutes with you, but what is it that you had to say about everything?
Judge, I'm gonna come down and see him by the end of the week. That was my plan. I just am finishing the trial in New York, and then I'm gonna spend whatever time he needs. Essentially, Judge, what Mr. Whitenauer and I are gonna place on the record is there is no disposition, no plea. The plea, as the prosecutor will state, is essentially a 30-year sentence, and we're gonna set a trial date.
Okay. So, Mr. Lafargue, are you okay with just speaking with your attorney later about what you need to speak with privately about?
Yeah, that would be okay.
Okay. So, Mr. Brackley, you said set a trial date. You know, this is set for trial on the 17th. There's a case. I don't believe in hiding the ball. There is a case that's scheduled ahead of it that is set to go unless there's a plea, but yours more than likely would be next up.
But as a pro hoc lawyer down there, Judge, it's my responsibility to do what I have to do to follow the local rules. My only request would be, I do have a case from 2021 that is pending. It's an incarcerated matter. It's a murder case, but it would only be a case of about 2 weeks, which is supposed to start around the 7th of February 17th. I assume, Judge, that this matter will not be concluded by then. Now, I will come on the 17th. If that's your preferences, I do follow the local rules. But if there is any way to get a continuance in February 15th.
Well, wait, no. January 17th is what we're looking at for this trial.
Yes. Right. So I think this case, Judge, will probably.
But you had said February, your conflict was February 17th.
Right.
Well, I mean, I guess what's the conflict?
I think we'll finish this case in 2 weeks, Judge. Is that fair?
Well, that was going to be my next question for Mr. White now. How long do you think this case will take?
Judge, it would be probably a 4-day trial.
Okay. So it looks like we're talking a week. So it should be done in plenty of time for your February trial.
That's fine, Judge. I respect that. And I will be down to see Mr. Lafargue within the next couple of days.
Okay. And just one more time, Mr. Whitenauer, can you put on the record what the offer was? Can you go ahead and do that?
Yes, Judge.
Or is?
Yes, Judge. For a plea to the count of murder and possession of firearm during the commission of a felony, state's recommendation would be life with the possibility of parole for the 5 years on the possession of a firearm. We'd be asking that be consecutive but suspended. If this case does proceed to trial and the defendant is convicted, the state would be seeking life without the possibility of parole.
Okay. And you and your client are turning that offer down, correct? Mr.
That is correct, Judge.
All right. It's a serious trial. But the offer's pretty simple. Life with parole is the offer. If you go to trial and if you're convicted, you could be facing life without parole. So, Mr. Lafargue, Mr. Brackley is going to come down and speak with you, and you can talk about the potential for the trial. And I don't think there's anything else we have to go over, is there?
No, Judge. I would just inform the court and defense that at previous calendars, I have advised that the state was seeking some additional DNA evidence regarding the firearm. I do want to let the court and defense know that I've not yet received that report, but as soon as I do, I will be providing that to the defense.
All right.
I'm aware of that, Judge. We've been discussing it.
All right. But other than that, you're both ready for trial.
Yes, sir.
Yes, Judge.
Okay. All right. You're both excused.
Thank you, Judge. I'll hang up now.
All right.
Thank you, Judge. May I be excused?
Yeah, you're excused, Mr. White now.
Thank you, Judge.
All right. We're ready for the plea. Go ahead and bring out Blackwell.
Hey, Flo, bring out Blackwell. You heard me? Hey, Flo. Flo. Bring out Blackwell.
Okay, this is 23 SC 1863881, Kenneth Blackwell, who's present in the courtroom with his attorney, Ms. Jones, and we have Ms. Simmons representing the state. Ms. Simmons, you have a negotiated plea to present?
Yes, Your Honor.
Go ahead.
Mr. Blackwell, could you raise your right hand? Do you solemnly swear or affirm that the testimony you're about to give to the court in this matter, excuse me.
Need some water? You right?
Need my water. Oh, geez. My apologies.
No problem.
Let me start again. Do you solemnly swear or affirm testimony you're about to give in the matter before the court shall be true to the best of your ability? You can lower your hand. Could you please lower your hand, sir? Could you please state your name?
My name Kenny Blackwell.
And could you spell it for?
Blackwey.
I'm sorry?
It's Keth. Blackwbley. It's Kenny Blackwell.
Yes, my client has a limited education and went through special ed. His name is on the docket, Kenneth Blackwell.
Mr. Blackwell, are you now under the influence of any medicine, drugs, or alcohol?
No, I don't do that there, ma'am.
Is there a medicine that you normally take that you have not taken today?
I took it today.
And having taken that medicine, do you think it will affect your ability to understand these proceedings?
Yes.
Well,
Does it affect the way, can you proceed after you've taken that medication?
Yes.
Okay.
How far did you go in school, Mr. Blackwell?
12th grade.
Can you read and write in the English language?
I can't read about all that much. I've been studying. I graduated though.
Okay. Have you had the opportunity to review the document that charges you in this case, indictment number 23 SC 186381?
Yes, I'm taking the program though.
Do you fully understand the nature of the charges pending against you?
Yes, I plead guilty.
By pleading guilty today, you are giving up certain rights, which I will now list for you. The right to a trial by jury, the right to be presumed innocent, the right to confront any witnesses that may testify against you, the right to subpoena any witnesses for your defense, the right to testify yourself and to offer any other evidence in your defense, the right to have an attorney to assist you throughout the trial proceedings, and the right not to incriminate yourself. These are the rights that you will be giving up by pleading guilty. Do you understand?
Yes.
Do you understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial by jury on these charges?
Yes, I understand.
You understand?
Yes.
You are pleading guilty today to count 1 in the indictment, terroristic threats and acts, for which there's a minimum sentence of 1 year and a maximum of 5 years. You are also pleading guilty to count 2 in the indictment, criminal trespass, with a minimum of 1 day and a maximum of 12 months.
Yes.
You understand?
Yes, ma'am.
Are you now serving any other sentence on probation or parole for anything, anywhere?
No, ma'am.
You're entering today what is called a negotiated plea. And Your Honor, the state's recommendation with respect to this indictment is On count one, 1 year to serve, and that 1 year will be commuted to time served. On count two, criminal trespass, that will be 12 months to serve, commuted to time served, which will run concurrent with count one. Do you understand that the court is not required to follow that recommendation, but can sentence you up to the maximum sentence permitted by law, which maximum sentences I have previously stated?
Yes, ma'am, I understand.
Do you understand that if the court does not accept this negotiation, you have the right to withdraw your guilty plea?
Yes, ma'am, I understand.
Are you entering your plea today with an understanding of everything I have said so far?
Yes, ma'am.
Has anyone used any force, threats, or promises which caused you to plead guilty against your will?
No, ma'am.
Are you satisfied with what your lawyer has done for you in this case?
Yes, ma'am.
Do you have any more questions for your lawyer before we go on?
Well, I'm taking the program, I'm taking the program inside the jail.
Have you understood everything that I have asked you so far?
Yes, ma'am.
Understanding all of your rights, do you wish to enter a plea to these charges today?
Guilty, ma'am.
Is your decision to plead guilty made freely and voluntarily?
No, ma'am.
Those are too big of words. Is anybody threatening you? Am I twisting your arm to get you to plead guilty?
No, ma'am.
Are you pleading guilty because you want to plead guilty?
Yes.
Did you in fact commit the offenses to which you are pleading guilty?
Yes.
Counsel, do you waive, do you waive a reading of the factual basis? Would you stipulate that there's a factual basis for this plea?
We stipulate that there is a factual basis for the plea.
Mr. Blackwell, are you a United States citizen?
Yes.
If you were not a citizen, do you understand that by pleading guilty today, you would almost certainly be deported from this country?
Yes.
Mr. Blackwell, if you wish to challenge this plea for legal error, you have one of two ways to do it. Your lawyer can explain what these ways are and how they work, but I must advise you of some time limits. The first way is by direct appeal, and you have 30 days from the date the sentence is entered to file this appeal. The second way is a habeas corpus petition, and you have 4 years for a felony and 12 months for a misdemeanor conviction. Do you understand these time limits?
Yes, ma'am.
Do you understand that you are not allowed to possess a firearm as a result of entering this plea today?
Yes, ma'am.
Do you understand that if you are found in possession of a firearm, you could be charged with another felony, which carries up to 10 years in confinement?
Yes, ma'am. Yes, ma'am.
You understand that, sir?
Yes, ma'am.
At this time, Judge, with respect to Mr. Blackwell's criminal history, he has 65 cycles of arrest and at least 7 previous felony convictions. And most of those convictions, Judge, after reviewing his criminal history, would seem to be motivated, or the underlying factor would seem to be his mental health condition. And it's for that reason, Judge, after discussing with counsel, that the state has made the recommendation that it has made in this case. Nothing further from the state, Judge.
All right, Ms. Jones.
Thank you, Your Honor. As indicated, my client is 59 years old. He did complete 12th grade, but it was special ed. He was found not competent initially in a report dated November 22nd, 2023 by Dr. Rosenkratz. He did indicate that Mr. Blackwell had limited ability and could survive a plea or get through a plea. However, he would not be competent for trial. He does not understand complex legal words. I often have to break them down, which is why he's struggling here a little bit, but he has indicated to me numerous times he wants to he wants to plead guilty to this charge, to these charges. He understands that he cannot go to Georgia Tech. He is trespassed from Georgia Tech. That's how this all arose, is he was at Georgia Tech. The police officer attempted to arrest him, or did arrest him, and they exchanged some words, which is the basis for the terroristic threat, Your Honor. We are respectfully requesting that you follow this plea negotiation. He does live with his aunt. He does get SSI, and we're hoping that he can continue to get his SSI and continue to stay on his medications.
Yes.
Yeah, I read the indictment just to get a feel for what this was about. And the plan is for him to go back in with his aunt?
Yes.
How long has he been in jail for?
He's been in jail 367 days at this point. I know the calendar says 343. I'm not really sure, but they may have booked him out when he went to, I think he did go to Georgia Regional for a stint, but I show right now the records are 367.
Does his aunt live near Tech?
No, she's still there by our tower.
I think he was just
I was
loitering.
going to the game.
You were going to the game?
Yes, I was going to the ball
All right.
game.
I think he was trying to go to the game.
I was trying to go to the game.
Yeah. Well, but you got that?
Yeah.
Your attorney
Stay
told you
put,
you're not
stay
allowed
put.
over there anymore,
I'm
right?
not going back over there. I'm
No
doing
more
the right
going over
thing.
there. Okay. All right. All right. And he was ruled competent for a plea, but not necessarily a trial.
That's correct. And I had an extensive conversation with Dr. Rosenkranz in regard to that.
All right. Mr. Blackwell, do you understand the nature of the charges against you?
Yes, I understand.
You have just heard from Assistant District Attorney Simmons explain all the rights you give up by entering this guilty plea. Is it your wish to give up these rights and have this court accept your plea of guilty?
Yes.
Okay. Do you understand that the court is not bound by this recommendation or the agreement, and I can sentence you as I deem appropriate?
Yes.
Are you pleading guilty because you are guilty?
Yes.
Ms. Jones, are you satisfied that your client is competent and understanding that the plea is voluntary and there is sufficient factual basis for entering the plea?
I do.
Okay, I find that there is sufficient factual basis for the charges. I also find your plea of guilty to be knowingly, voluntarily, and intelligently entered. I will accept your guilty plea and sentence you to the negotiated plea as follows. So on count 1, the terroristic threats will be 1 year to serve, commuted time served. Count 2, the criminal trespass will be 12 months to serve, commuted time served, and those two counts will be concurrent with each other. Is there anything else?
Not from the defense.
Okay, Mr. Blackwell, good luck.
All right, Mr.
You're
Blackwell.
excused.
I'm taking the program.
What's the program?
It's at the jail. He's in restoration.
Okay.
At restoration pod.
All right, all right. We'll see you later.
Proud that he's done well.
All right. Is there anything else?
No, I think we're done.
Okay. All right, we will see you later.
We're staying for ice and green tomorrow.
Okay.
Can I ask you about the last one, Mr. Blackwell? I just want to decide everything. Works. 1 year to serve. And then 12 months. 12 months. Next time.
Does that help it?
Usually it's that one.
Yeah.
Oh.
All
Okay.
right, well, now we know that happens.
So say, you're like the Fonz with the,
No. I hope you're not getting a cold.
I hope not. They're just gonna say,
I hear you on that. They like to keep them. I'm tired of this.
oh, we'll see you tomorrow. Oh, not tomorrow. What am I saying?
Thursday.
Thursday.
That'll be my next project. Maybe take a look at that. Ha. It's always tough when you Have a break.
Oh, Lord.